Good morning. My name is Stan Harris. I'm the president and CEO of the Louisiana Restaurant Association. We want to welcome you to this morning's webinar that's focusing on wage and labor issues. Should you have any questions during the webinar, please use the chat feature, or you can email me directly at sharris@lra.org, sharris@lra.org. Time allowing, at the end of the program, we'll try to address your questions. Most of you are seeing news reports of bills that have passed in the legislative process and been signed into law from the 2024 Louisiana legislative session. Before we jump into today's topic, I'm going to briefly review a few items of interest to many of you. Each session has its own rhythm and flow. This one is the beginning of a new 4-year term, and it adds the intensity of many new members. In the House of Representatives, we had 31 new representatives, many of whom have never served in elective office. In the Senate, we had 11 new senators, including 9 who came over from the House and 2 who have never held elected office. Fortunately for the LRA, the president of the Senate, Cameron Henry, had his first job intern at the LRA, and his in-laws own Domalice's Po' Boys in New Orleans. We also have Senator Kirk Talbot, who owns Lucky Dogs in New Orleans, who's an LRA member and been a great supporter of anything that we need to get done at the Capitol. Coming out of the second special session, which focused on crime and criminal justice reform, the legislature passed the authorization of constitutional carry of a firearm by any resident not otherwise prohibited and being at least 18 years of age. Places that prohibited the concealed carry of handguns before remain under this law. These include any location where firearms are banned by federal or state law, a law enforcement building, detention facility, courthouse, polling place, municipal or other public building, the state capitol, an airport, a place of worship without the permission of the administration, a parade or demonstration for which a permit is issued by a government entity, and a school bus or school. The law does not impact the rights of any private property owner, such as a restaurant, business, hotel, retail store, to prohibit or restrict access to persons possessing a concealed handgun. We will be providing via download a sign that can be placed in a place of business that chooses to prohibit concealed weapons, which also contains the Louisiana statutory reference to property rights. Concealed weapons remain banned from all bars with a Class A general permit. If someone with a concealed weapon is found to have consumed alcohol and they have a blood content of more than 0.05, reminding you that the limit for driving under intoxication is 0.08, they can be arrested with reasonable suspicion. The LRA worked to support 2 different bills related to the heavily traveled tourism areas in New Orleans and for carve-outs that would have allowed for concealed carry for those persons who have an enforced concealed carry permit. Both bills face strong opposition from the National Rifle Association, and only one with an increased penalty for a negligent carry passed both chambers. This year, we also saw multiple bills that would have prohibited businesses from going cashless, requiring electronic or credit card payments only. We worked to defeat these bills, believing it's up to our members to determine what form of payment they choose to accept. There were also multiple bills that sought to either prohibit or cap surcharges on credit card transactions related to discount or processing fees. We were successful in defeating those in committee early in the process. In the labor committees, we worked to defeat multiple bills that sought to establish a state minimum wage, repeal the tip credit wage, or require more restrictive equal pay provisions. The LRA has historically opposed wage mandates, opting for the market to set wage levels. We supported the passage of Act 603, which will take effect on August the 1st. Authored by Representative Roger Wilder, a Smoothie King franchisee, this sought to repeal the statutory mandate that 16 and 17-year-olds receive an off-the-clock break of at least 30 minutes after working 5 hours on any shift. This law has been in effect for 47 years and been used by the State Workforce Commission to levy significant fines on operators unaware of this rule or who have a violation. While the break period for 14 and 15-year-olds was retained, this will encourage many quick service operators to now consider hiring those aged 16 and 17. Finally, for those interested in a proposed constitutional convention, I expect there'll be much more limited approach to this, focused specifically on taxes. While many would embrace phasing out the state income tax on the individuals, it will require replacing the $4 billion it currently generates. I expect they'll work on inventory tax, industrial tax exemptions, and other programs that are seeking to find a path to becoming more like Texas, Florida, and soon Mississippi in eliminating the state personal income tax. And now it's my pleasure to introduce our presenter for today's webinar. Michelle Anderson is a partner at Fisher Phillips Law Firm with over 20 years experience in executive management, workforce development, and employment law. Michelle serves as the outside general labor and employment counsel for the Louisiana Restaurant Association. She works closely with our members and our team here at our LRA headquarters. Their firm represents employer interests in litigation, collective bargaining, and other workplace-related matters. Today, Michelle will guide us through the new federal overtime rule, raising the salary threshold to nearly $59,000 by 2025. She'll share critical steps for compliance and strategic planning to protect your business. And this session is essential for anyone looking to be compliant with these new overtime regulations, the first of which take effect in a brief 12 days on July 1st. So, Michelle, welcome, and thanks for joining us today.
Thank you for having me. It's good to be with everyone. So let's just jump right into it. So this is obviously not meant to be legal advice. If you need legal advice, you can certainly reach out to us and we will help you evaluate your individual circumstances. But we want to give you just some general framework of what's going on. Some of this will be review. Many of you may have been part of other presentations where we have talked about wage and hour issues. Often we have really focused on the non-exempt, your tipped employees. The focus today, however, are the folks that you have been treating as salaried, exempt, and paying a salary for, whether that was correct or not. We're going to talk about if there's been a mistake, now's the time to fix it. So we always start with just sort of the background that the Federal Fair Labor Standards Act, or the FLSA, sets some very minimum requirements. Of course, there's a minimum wage requirement, which currently is $7.25 an hour. As Stan mentioned, Louisiana is not a state that has a higher minimum wage. If you are operating outside of Louisiana, however, you may be operating in a state that does have a higher minimum wage. So, of course, the Fair Labor Standards Act does enforce the applicable minimum wage. So, for example, you may have noticed I also practice in Florida. Florida does have a higher minimum wage. The other principle is if you work over 40 hours a week, that you're entitled to overtime at 1.5 times your regular rate. There are record keeping requirements, and then of course there are limitations on types of employment for minors under the age of 18. So of course you have to realize that when this law was passed back in the 40s, the terminology is that an employee has to be paid for all time they are permitted to suffer work. So if you know about it, you have to pay for it. Things that you may have not even approved, but if you know about it, still have to pay. If they work through a meal period, if they come in early, they leave late, they're taking emails, calls, off duty. And again, this will sort of tie into the fact that if you have people who have been salaried and have been doing all of these things, and now we might have to look at putting them to a non-exempt status, now you're going to have to factor in, are they doing these other things that maybe before it did not matter so much? So what are the exemptions? So there can be exemptions from minimum wage and overtime. Some are both. But the default rule is always that we start with the assumption that somebody is non-exempt unless a particular exemption applies to them. So the white collar exemptions, the main ones that we probably talk about our executive exemption. These are going to be your managers, administrative, professional, and then highly compensated, which we don't see a lot in the restaurant industry, but we're going to talk about it anyway, in case you have people that maybe work for you in more of a headquarters capacity, or if you maybe perchance have some other sort of business models. But generally, we have to establish that there's a minimum weekly salary. They're paid on a salary basis, and they meet the job duties test for exemption. So how we got to where we are today, and some of you who have been on prior presentations may recall that back in 2016, the U.S. Department of Labor, the DOL, issued a final overtime rule that was supposed to be effective December 1 of 2016, and it was raising the minimum salary from $4.55 a week to $9.13. We did webinars back then. There was a lot of flurry of activity of getting people ready leading up to that December 1 date. And then 8 days before it was supposed to take effect, a court in Texas entered a preliminary injunction blocking the rule nationwide. So many businesses had gone in and figured out who was going to they were going to be able to maintain as salaried exempt and who they had not, and had already done all those conversions. And hopefully we don't get to that situation this time, but as Stan mentioned, we are very close to July 1 when the new rule will take effect. So then in 2019, there was another final rule issued. This would be called Overtime 2.0, and it increased the minimum salary from $4.55 to $6.84, and that took effect of January 1 of 2020. And that rule did take effect. Again, many of you maybe have already been working under this model for the last several years, where you had to at least be paying $6.84 a week to people who you considered to fit within the exemption. The change between the 16 and the 20 rule, however, was that there were no automatic increases. They also put together a highly compensated executive salary that went from $100,000 to $107,432, whereas 10% of that could be made up through non-discretionary bonuses or incentive pay. The caveat being that if the person had not achieve those bonuses or incentives to get to that 107 number, that you would then have to true them up at the end of the year to ensure that they made that. So now we have what we'll call 3.0 in the overtime rule. So effective July 1, that salary threshold for exempt employees is going from $6.84 per week to $8.44 per week. So that's 43,000 and change annualized. The second increase is planned for January 1 of 2025, where it will jump from $844 to $1,128. So to Stan's point, it's going to push you up over that $50,000, closer to $60,000 a year rate. And the law also has plans for automatic updates to the salary every 3 years based upon national wage surveys that the DOL will partner with, usually with the Bureau of Labor Statistics, to look at sort of, what should be the annualized number that they're looking at. And of course, some of you are thinking, well, isn't that a challenge? Because of course, economies are not necessarily the same in every state and every locality in the country. And so, yes, that is certainly a concern. And then for the highly compensated executive, it goes from $107,432 to $132,964 effective July 1, and then up over $150,000 come January 1. And again, automatic updates every 3 years. So what do we need to be doing right now? So the first thing is look at the people that you're treating as exempt. Now, just because you pay someone a salary does not mean that they are exempt from overtime. The test is, do they at least meet the salary threshold that's paid weekly? Now you can pay them bi-weekly, but when you break it down, you're looking at, do they at least make currently $6.84 a week? And then do they meet the job duties test for exemption? They don't meet the job duties test for exemption. It does not matter what salary you're paying them. That's not in compliance with the FLSA. So the first place that I would start is, are there any current people on salary that are making less than the $844 a week that's set to take place July 1. If they are, then of course, are we going to bump them up? Or are we going to consider reclassifying them as, salary non-exempt? So if you're looking at doing this, of course, you can work with counsel like us. We can do an audit that would be privileged, or certainly you can do it yourself. Just know that, anything that any decisions that you make, any documents that you pull, any emails that you send to each other about this, those things are not going to be considered privileged. So in the event that there is litigation at some point in the future or a DOL audit, those things, of course, are discoverable if there is no, attorney that is part of that review. So remember that the salary does have to be paid free and clear. So you cannot make reductions to someone's salary based upon the quantity or the quality of the work. They have to be paid the full salary for each work week in which they perform any work. The only safe harbor provision is that if they miss work for a full day due to a personal reason, if you have a policy that gives them time off for sick pay, then you can obviously swap out the paid time off, sick, vacation, whatever it is. If they are suspended for violating a safety rule or workplace conduct rule, if they serve on jury duty, if they serve on military leave, if they take any unpaid FMLA, and of course you can prorate the salary in the first and last week. But otherwise, it is very difficult to make any deductions other than the standard deductions for payroll from someone who is salaried. So I mentioned earlier that we have to make sure that individuals fit the job duties test for whatever exemption you have them performing. Just the salary alone will not be sufficient to mean that they are properly classified. So oftentimes in the restaurant industry, what we see are the executive exemption. So these are people who are managing. They're managing, maybe they're managing one of your locations, maybe they're managing, the front of the house, the back of the house, or a particular department within your business. But they have to at least regularly direct the work of 2 or more full-time employees or the equivalent. So, 4 part-time employees, but they have to be responsible for, hiring, firing. Now, they may not be the ultimate person that makes the decision about hiring and firing. That might be reserved to, someone in human resources or someone at a higher executive level to, bless the decision. But they can make those recommendations about hiring and firing, participating in the process, advancing, promoting people, evaluations, that their input is given a particular weight. And so typically your assistant managers and certainly managers in training are not going to fit into the executive exemption, but your general managers, folks like that will. The administrative exemption, I don't see too many at least in the restaurant itself. But sometimes if you have a larger organization where you have people you've got a CFO, COO, you've got, an HR, VP, you might have folks that are at a higher level and would fall within the administrative exemption. So it's non-manual work. It's related to the business, and they have to have independent judgment and discretion of matters of significance. So basically, they have to be able to essentially bind your business. They have to have enough latitude in their job where they can interpret policies, or they might be creating policies that will affect your business operations. They may be entering into some sort of agreement. So for example, sometimes human resources folks are in the business of procuring benefits and different things, for the business, and they vet those contracts, and then they ultimately, decide, again, maybe with some executive level authority, about whether or not they're going to enter into those agreements. But this is generally not just going to be someone that is, say, a receptionist, an executive secretary, someone who's just processing payroll or doing accounts receivable, or your billing, things that are going to be very rote, remote, things that they don't have to exercise any sort of independent thought or discretion in doing. And so if you have any administrative folks that you've been paying a salary, then this might also be the time to look at reclassifying them. There are professional exemptions. I would say the one I see most common would be your folks who are professionally trained executive chefs, where they've had to, get particular specialized training, and they're in charge of creating all of your recipes and your menus, and then of course maybe working the kitchen and all of that as well. The highly compensated employee, and again, I know we don't see that very often in this industry, but I bring it up for purposes of being complete. The highly compensated executive meets the salary threshold, and then one other test for exemption. So it doesn't have to be they meet the entire test for the executive exemption, the entire test for the professional or the administrative exemption. It really hinges off of what the salary is, and then do they have at least one duty that falls within that job, that job classification. And so obviously, paying someone well over $100,000 a year, currently it's 107, it'll go up to close to 133, and then close to just over 150 in January 2025. I would say that when the DOL comes in and is looking at those kinds of numbers, they're usually not concerned that they're not being paid sufficiently, under the Fair Labor Standards Act. They're more going to be looking toward your folks that are closer to the that 844, or again the 1128 come January 2025, and looking closer more at their job duties and whether or not they're properly classified. So if folks are making less than the minimum salary that's taking effect here in the next handful of days, your one option is, are we going to raise them to the minimum salary level? Now, you might choose to do that for this first one. Because maybe they're close enough, but you might be making a different decision when it comes to that January threshold increase. And it is okay to decide, okay, we're going to make this first one, but then come January, we can't go all the way up to 1128. So we're going to, at that point, put them back to a non-exempt hourly pay. So obviously, if you do reclassify people as non-exempt, then they are going to get paid for overtime, which is anything that they work, more than 40 hours in a work week. And a work week is the 7-day period within which you determine, when do you achieve 40 hours. So is that Sunday to Saturday? Is it Monday to Sunday? What is your 7-day period? Because that's, of course, what we're looking at. So if we're looking at that, we're going to reclassify exempt employees to non-exempt status, there are different ways to do that. Of course, you can go the straight hourly. You could put them to salary non-exempt, although that does still require you to pay overtime on the halftime. So, you can say, well, the salary represents either all hours worked for the week, and then you take that salary and divide it by the hours worked to get the regular rate, divide that in half and multiply that by the hours worked over 40. You can do a fluctuating work week, which is, again, still a salary model. Again, but the challenge is anytime you pay someone a salary, even if they're not exempt, you're still going to be subject to those salary rules where you cannot just deduct the salary for quantity or quality of work. So there are some employers that don't like having salaried non-exempt people, because if they work 30 hours, they get their salary. If they work 50 hours, they get their salary plus an additional halftime on overtime. So if you aren't wanting to do something, in the fancier realm like that, and you want to put someone straight back to hourly, of course you want to figure out what is the right rate to pay them, because the DOL presumes that what employers will do is take that salary, divide it by 40 to come up with an hourly rate, and then all these folks will become eligible for more pay by doing time and a half, whatever that hourly rate is. But if you're savvy about it, what you're going to do is you're going to figure out, okay, how much are my folks working? And so if I want to build in the thought that there's going to be overtime or anything else that might impact the regular rate, if you do any kind of incentives or bonuses that might impact the regular rate, then this is where you're pulling out the Excel spreadsheet and, doing some modeling of, okay, this person makes this much of a salary right now at, 50 hours a week, that's X, but I have to factor in, that they're going to get some overtime too. So this is the time, to be sort of playing around with that number if you don't want your overall cost per that employee to increase exponentially just by taking that salary and dividing it by 40. So when we talk about bonuses and incentives, there are the discretionary bonuses, which are like, hey, we had a great year, we had a really good month. Here's an extra $50. Here's an extra $100. That was something that you didn't have to do. It wasn't something that was necessarily expected. There was nothing that the employees did or did not do to generate sort of that little extra amount for them. It's discretionary. We don't have to factor it into the regular rate and overtime week. The other kind though are non-discretionary, where maybe we've set up some sort of incentive program for people who have, good attendance, for people that I don't know, do so much in sales, whatever it is, but we have set up some sort of framework and anticipation that if you behave in a particular way, if you perform in a particular way, that you will get a little extra something. And so that little extra something, we have to look, was it earned over just a calendar or over a work week? Was it earned over a pay period? Was it earned over the course of months? We have to figure out what is the impact on the regular rate in an overtime week. So again, this is where I would say if you've got that issue, getting legal counsel that can sort of help you through that modeling and those considerations is a good thing. All right. I've just kind of said this. So you want to determine if the bonus has to be included. So again, anything that you set up a bonus or incentive type of program, you have to look at the time frame. Again, a week, 2 weeks, a month, 6 months, a year, and then you have to figure out, okay, over what period of time did they generate it? So say it's a month, and we've had 4 work weeks in that month. Say it was a $200 bonus or incentive. We divide that by 4 weeks. $50 a week, and we add that $50 into any week where there was an overtime amount, and then we have to figure out what the overtime rate is again. And oftentimes it's not going to be a ton, but the exposure for not having done that right can be the problem. If any of you have ever been through a wage and hour audit with the Department of Labor or been through any kind of litigation with a plaintiff's lawyer, you know that oftentimes the amount owed to the employees isn't very much, but by the time you multiply that by 2 for liquidated damages and add attorney's fees and costs, you're starting to talk about, some real money. You will have this presentation available to you afterwards. I will put it in a PDF and I will send it to Wendy because obviously the calculation can get a little bit confusing. And so I don't want anyone to feel like you have to, write it down or take a screenshot. We'll just provide this to you. But essentially, as I was explaining earlier, you do have to figure in, how many hours they worked, what is the bonus, figure out the regular rate, and then what is that little bit of a bump that you have to do to give that little extra amount on the overtime calculation. It might not be, again, very much, but it is enough that if you don't do it correctly, that you do have some exposure there. So when you're working through your decision, obviously timekeeping solutions are important because folks who have been exempt up to this point likely have not been tracking their time. And so we've got to make sure that they understand the requirement to start tracking their time and being accurately. Will there be any impact on benefits? Sometimes businesses are only offering certain benefits to their salaried exempt employees. Obviously, I'm not necessarily talking about healthcare, which kicks in under the Affordable Care Act at 30 hours or more. But sometimes you offer other things to your salaried exempt employees that you might not offer to your exempt employees. How will this impact, morale? How are we going to ensure consistency? Because sometimes people who are, well, now you're eligible for overtime, but you're no longer getting a salary, and you're going to have to track your time. How are we going to sort of message those things to folks? So you do want to make sure that if you are going to be making changes, I always say put those things in writing, because we know that when we just tell people things, oftentimes they develop amnesia, and then down the road where it counts, where we need to prove that we notified them of changes in their compensation and the expectations, that of course they pretend like they didn't know. Obviously, when you're changing someone from exempt to non-exempt, now things like meal breaks and rest periods and paying for those and tracking those become important. So if they've never had to worry about clocking out for, say, a 30-minute meal period, now you're going to be training all of those folks to do those things that maybe they may never have done before. There are some states that do have a notice requirement. Louisiana just happens to be that we need to tell them in advance of the change. So if you're going to be making a change July 1, you want to try and notify them at least in the pay period within which that starts before it takes effect. Some other states do have different requirements. I mentioned this, earlier. Do you have different policies for exempt versus non-exempt employees? Obviously, if you've got people in your locations, they're probably not working remotely, but do you have other types of support staff that normally work, say, in your office, and maybe they're working remotely and they were salaried exempt, and now you're going to have to put them to hourly? Obviously, you want to have a remote workplace policy that addresses the expectations of what is, on the clock work and tracking their time. When people work remotely, obviously we don't have eyes on them, and so that can be difficult, and we can have issues where people are working off the clock, or people are riding the clock and they're not actually working, but they're claiming that they are. So again, any managers who will have newly sort of non-exempt people, what are the record keeping requirements? Because again, the Fair Labor Standards Act does have record keeping requirements for non-exempt employees. If you have people who are traveling, typically with managers, it was all in a day's work. They were salaried. We didn't care. Now, if you will have folks that are going to be non-exempt, there will be times that they'll be required to be paid for travel. Do they need to have approval for overtime? Obviously, even if someone works overtime without approval, you still have to pay them. You cannot engage in self-help and dock that time. You can discipline them, but you still have to pay them. Ensuring that people are not working off the clock. Just all of the various things that could come up that, again, with salaried exempt people before, maybe we were not as concerned, and now we will have to be if you're not going to be able to bump them up to that new salary requirements. So you want to stay up to date on legal challenges. We are just a handful of days away from the first increase going into effect. At the end of May, there were a handful of business groups that filed litigation. They're trying to block it. But again, you just can't count on that. 2016, it ran almost right up to the minute. And then, in 2019, it ended up taking effect. Although different than the 2016 model, it did still end up taking effect. One of the things that they brought up though in the 2016 round is that they had not gone through their proposed rulemaking, which is through the Administrative Procedures Act, and they did do that this time. There was a comment period before it was published in the Federal Register. And so I think it's a little bit harder to attack sort of procedurally where they were able to do that before. So, these various tests have obviously been in place for a very long time, but I will say this is sort of a careful what you wish for moment, because if the salary basis test is removed, which is one of the arguments, is that the DOL shouldn't be able to do that, although they've done it since the 40s. But if that salary threshold test goes away, then we might be looking at going back 20 years to when they had a short duties test and a long duties test. But even that still had some sort of salary threshold requirement to it. So I think while employers oftentimes don't like that salary threshold, it does, however, sort of limit the ambiguity in sort of what the test is. The job duties test has not changed in 20 years and continues to be the same. I think there are many of us that wish that they would also sort of go in and deal with the job duties issues, but particularly on the administrative exemption, but they haven't. So there's also another Supreme Court decision that we're watching. It could come down any day now because we're getting to the end of the term, but it's the Loper decision. Although not an FLSA decision, what it seeks to attack is whether or not the deference standard that was established under the Chevron case in 1984 should be upended. And so what Chevron did was it gives deference to the agency's reasonable interpretation of ambiguous statutes that it administers. And if you know anything about the way laws work, I always explain to people that laws are a funnel. You have the legislative, executive at the top, and these things then are passed, but it's generally just a framework. And so then they go to agencies who have subject matter experts in these areas who then formulate the regulations. And then, in the federal side, they're supposed to go through typically a public comment period, and then before they're published in the Federal Register, and then there is an effective date. So the challenge, of course, is overturning Chevron entirely will create further confusion and inconsistency, because that will then allow courts who are not subject matter experts in any of these things to, in many ways, potentially legislate from the bench, or it will create a lot of inconsistency and confusion between various states and various circuits. And the Supreme Court cannot resolve every single dispute. And so it could create more problems than it solves, but we shall see. We should know in a matter of weeks. But whether that would potentially upend the salary basis rule that we're looking at, we just don't know. And I don't even want to guess at this point. So as mentioned earlier, obviously non-compliance with the Fair Labor Standards Act does have, some penalties to it. It's not just the back wages, but it's the liquidated damages, which is for every dollar of back wages owed, you could owe up to an additional dollar in liquidated damages. Civil money penalties, which are assessed on a per violation basis by the Department of Labor. And that's not money that goes to the individual, it's money that goes to the government. And we have seen more civil money penalties being assessed, even in initial investigations by the Department of Labor, that we didn't see this, several years ago. There can be individual liability because, of course, the Fair Labor Standards Act does not just limit the definition of employer to the business itself. It can be owners, it can be managers, anyone who is responsible for the quote unquote unlawful pay setting practices. There can be criminal penalties, and if you do have employment practices liability insurance, oftentimes it does not cover wage and hour claims. It may have a rider for cost of defense, but I always tell folks, look, check and see first, do you have employment practices liability insurance? And if you do, does it cover wage and hour? Because honestly, in today's sort of legal scheme, I would say you're going to see more wage and hour issues than you probably are other things. And of course, these are often pled as a collective action because an individual plaintiff claim might not be worth very much money. Just let's just say it's worth $2,500. But if you have a group of people, a group of servers, a group of bartenders, a group of delivery drivers, people who are similarly situated, well, looking back up to 3 years, of course, now those are things that start to look attractive, to a plaintiff's lawyer, because they can get more people into the case, which of course means more money, more recovery. So just some final things. Again, Louisiana doesn't have anything necessarily special. We do have a wage payment law where if you don't pay final wages timely, you can be on the hook for up to 90 days of penalty wages. But we otherwise generally follow the FLSA when it comes to obviously the salary threshold, minimum wage, record keeping requirements, and obviously be patient. We don't know when this litigation is going to be over. Even if there is an injunction, it can be appealed. It goes back down. This is one of those things where I would not say, wait it out, because we're just quite frankly too close, to the timeline, to want to, wait it out at this point. Okay. All right. Yeah, don't fall for conventional wisdom. Everybody does this. I'm like, well, if everybody's doing it wrong, doesn't mean you're doing it right. They want to be exempt. Doesn't matter what the employee wants. They cannot waive their rights under the Fair Labor Standards Act, or they agreed to just be paid straight time for overtime. They can't do that under the law. None of those things will save you. Ignorance of the law won't save you. The only thing, being proactive and determining whether people are properly classified exempt and saving that information for when you need it, that's really the best thing. All right, we've got time for questions. So
Michelle, we've got some questions in the chat.
Okay.
So the first question is going to be, what amount of non-discretionary bonus can be considered in the salary total that should be calculated as a part of the salary? So that I think you made it fairly clear earlier.
10%.
Yeah, 10%. And then the second question is, what if a non-exempt employee works through their lunch period? Should it be considered part of their salary? I guess that gets back to the timekeeping piece of this, right?
Right. I mean, if they work, then they have to be paid. So anything that you have that's a auto deduct, they work so many hours and we auto deduct a 30-minute or an hour lunch, that I always tell people don't do auto deducts, because then you're running the risk of someone saying I worked and then you've got an off the clock claim. So if they work through lunch, they have to be paid.
Okay. One quick update too, Michelle, is we, through the Restaurant Law Center, which is part of the National Restaurant Association, we are one of the plaintiffs in this matter in Texas, and
Right.
It has not come up yet. We've been waiting for a decision on this for, oh gosh, probably 3 months, but they're expecting something any day now, or as they explained it to me, never. So it's one of those circumstances that we're typically at there, much like the off, the amount of tipped work for
Yeah.
tip credit work that we were we prevailed in Texas. It came over here to the Fifth Circuit. The Fifth Circuit Court of Appeals said okay, and then sent it back to the trial court.
Yeah.
The trial court said nope, we're going to get rid of the injunction and we're going to impose this, and so that's where we get where we are.
Yeah.
Next question is, what if you are a quasi-government agency? What if you pay 1.5 times comp time for hours worked over 40 hours?
So comp time, that's in the public sector.
Yes. So as a quasi-government agency, we have
Yeah.
some CVBs on the phone with us.
Right.
So I think that's probably where the question's coming from.
Yeah. Let me look at that, because it's still, you're still gonna have to pay that at overtime. That's not going to change the salary threshold issue. You're still subject, if you want someone to be exempt from overtime, you still have to meet the salary threshold, even if you're a public employer. So you're talking about when someone is non-exempt and you want to put the overtime into a comp bank, there's a statute that deals with that. So I can talk to you about that more offline, but it's not going to satisfy the salary basis test like we're talking about here.
Okay. Next question. Would you consider a highly compensated employee as any executive at a VP level or above?
Well, if they make the salary threshold, that would be at least, one job duty under the administrative test. More than likely, they probably meet the test for exemption outright at either administrative or executive. But for highly compensated, again, that's 107 and change right now, and that's going up to 132 and then 151 something. So you're less likely, I would say, to be challenged when you're paying someone at that rate, because you'd be able to show, well, they meet the highly compensated executive, and here's the one job duty they have that fits within one of these exemptions. So it's not as difficult as, say, these other folks.
All right, and the last question that we have up here is a little more complex. It says, for example, if in 2019 a highly compensated executive employee met the salary threshold, but their salary was not adjusted back then, and now they are not meeting the salary threshold, but would have met the threshold today had they been increased in 2019, are companies required to go back and consider that fact that this salary adjustment was not made? So you've got the distinction in that 5-year time frame.
Right. So under the Fair Labor Standards Act, willful violations have a look back period of up to 3 years. So you have, obviously, if you want to get into compliance, you're going to need to bring them up to whatever salary threshold is required now. But looking back over the last 3 years, you continue to run the risk of that exposure, that the person would come and say, I was misclassified as highly compensated because I didn't receive the salary threshold required. And so you are at risk for having them owing that difference of what you were paying them to what they should have been paid, ×2 for liquidated damages. And then, of course, if an attorney is the one that got you, they're going to stick their hand out and want some fees on top of that. So you can certainly go back and make it right and pay them the back wages. You can't get them to sign a release, but you can get them to sign what I call as an acknowledgement of payment, that recognizes that you did an audit of your books for this period of time. You determined they were owed XYZ amount, and they are accepting XYZ amount, and they are not aware of any additional amount owed. That's the best you can do. But that would at least give you a good faith defense that once you learned of the problem, you corrected it and took action to make them whole. Or you can let it ride and hope that they don't realize it.
All right, last question that we have in the chat. And this may fall into another conversation about sales exceptions. Does a commission fall into the bonus category, or can that be part of their total compensation, meaning that it gets them over that $58,000 threshold? Does that make them exempt?
Commissions are considered part of incentives too. So we would have to follow the requirements for how that gets factored in as well. So I would do some modeling. I would do some modeling of what that looks like.
So if it's that incentive that is an earned incentive versus just a discretionary bonus,
Right.
you're saying
Right.
that can be added to whatever the
That can
base is.
that can be, but I think 10% is your max. So it's not very much. It's not very
And
much.
and what about an exception for commission salespeople?
So that gets into whether they're outside sales. Are they truly outside? And I can share some information on outside sales. But
Okay,
oftentimes your inside sales oftentimes don't meet a test for exemption. So you've got, different
got
different
it.
requirements. Yeah.
Got it.
Yeah. Yeah.
All right, Wendy, do you have anything else? And do you have, Michelle, you have anything you need to wrap with?
Nope.
No, sir.
All right. Well, look, we appreciate everyone joining us today for the webinar. We know this is a highly technical and complex area, but it is something that I would be talking to my CFOs, my payroll providers, my management team to make sure that compliance is something that you're seeking, so that if these things take effect as we are moving toward expecting that to occur, you are prepared for it. And again, as Michelle said, it's always best to take corrective action when you learn of something that's non-compliant, and do it in the best and most informed way possible by sharing with someone an acknowledgement of payment so that they would sign off on that to show that they have been paid for those things. Anyway, Michelle, thank you so much for always being a great resource to us and trying to make something highly technical a little bit easier to understand. We really appreciate it.
Thanks, everyone.